I would like to call Mr. Satyakam sir to share his experience with us about his experience and the cases which he has dealt. So, Mr. Satyakam sir is a practicing advocate in Supreme Court of India and Additional Standing Counsel for Government of Delhi. He has extensive experience in medical negligence cases, consumer law cases, industrial and labor cases, as well as civil and criminal law. He has also assisted in many important matters such as Padmanabha Swamy Temple case, the Parliament attack case at the Delhi High Court and the Supreme Court, the Red Fort Shootout case, the Bombay Blast case, and many other constitutional matters at the Supreme Court. He has also been Amicus Curiae in various cases. So now I'd like to call Satyakam sir to please share his experience.
So, when we enter your college, there are two words which is highlighted: Satyam Vad, Dharmam Cha. So that's all this professional ethics is about. Although it is very general, Satyam Vad, Dharmam Cha. But that's all about it. But I'll demonstrate that how it is. Before that, I must start with what the Chief Justice of India said last week when he was inaugurating a research college in Goa. He said that the common law admission test, the current model of selection of law students for national law universities, may not result in the selection of those with the right ethos. So he said that the present system of education is not value-based legal education and may not bring about the kind of lawyer which are required for a career of law. So I would start with that. What did he mean? What was exactly that he was thinking when he said this? What is this right ethos which we require in the career of law? There are so many careers which we know of. There are people and they are making good money. There are people who are doing well in their profession. They are working hard. They are making money. So what is bad? If as a lawyer you read so much and you do so much of hard work and go and earn money, isn't it? So when you are doing so much, you must get the money in return like any other people. What do you say to that? I want a response. What do you say? Should you not get the money like any other person? Like you give something and in return you are given money? Likewise in this profession also, when you are giving your services, you should get money. Right? You are all saying yes. Right? Yes, yes, yes. Absolutely right. That is what we have to discuss here. That what is different between this profession and a grocer? What is the difference between a trade and business and a profession? What is that difference that makes it different from others? You are studying for 5 years, like people study engineering and then they do management course and then thereafter they go and then they get money, they get well paid. So the people in the legal profession should also get money and they should get paid. So what is the difference? Why should this profession, people should be lagging behind in competing with others in the society? Right? So this is a question which is not a new question. And I was trying to find an answer. And I came across an article written in 1944. This article, which says, what is a profession? The rise of legal profession in antiquity. So, Roscoe Pond, who I knew as a legal theorist, I did not know that he has written such a wonderful article about the legal profession. And he analyzes what are the professions, what are the traditional professions, and what makes them different from a trade and business, from any other business where you give and in barter you get something in return, or you get money as a reward or other rewards. So there is that difference. So he says that legal profession has three elements, or any profession for that matter, whether it is a medical profession, or he says the profession of ministers in the monastery, and he says that these are all traditional professions. So he says that there are three elements which are required for a profession to be called a profession: organization, learning, and the third, he says, spirit of public service. So let's understand quickly these three words. So organization, now organization also understand like trade and business and profession. You can have bodies like trade associations and bar council. What is the difference between trade association? You get yourself enrolled with the trade association, you get a lot of benefits, you get to park your car when there is something to be done together, you all go together and do it together. Likewise, even lawyers have their associations, they do go and do strike and they do all sort of things. So what is the difference? The difference is that this is a profession. Historically, it has a tradition, culture and ideal. So organization is required to tell us that how the very minimum standards have to be maintained for learning, so that people are trained to join this profession. And that's what the preliminary exercise is. You have a formal education of 4-5 years where you learn the basics of law, and then the learning actually starts. So there is learning, and I'll talk about what is the learning a little later. Then basic standards of colleges, etc. is required, and then they also talk about admission as a lawyer. So how do you enroll, who all can enroll, and then the basic standards of etiquette and manners and professional ethics. So they tell you that at least you have to do this, and if you don't do this, then possibly you are crossing the line. And if you are crossing the line, then you can be tried by a disciplinary committee of the Bar Council, and then possibly something will happen which would be adverse. But we don't have to bother about it. Why I am using this expression basic means moral standards are not for somebody else to tell you that this has to be your moral standards. But when you have to be tried and you have to be punished, there is a lowest threshold which is prescribed, that if you cross this, then possibly I have to question. So that lowest threshold has been provided in the Bar Council of India rules. But your standards are your own standards. You can make your own benchmark. You don't need somebody to tell you what is the benchmark. And the benchmark is Satyam Var Dharmam Cha. What is the benchmark? The benchmark is honesty. Now, this is contradiction in terms. Legal profession, people lie in court, they give false evidence and they get away. And I'm talking about honesty. It's too idealistic, isn't it? This is all bookish. It is actually not. I'll tell you why. Then we come to the further learnings. So what you do after you are taught by your professors the basics, jurisprudence as to why and how of law, why do you have law, what is law, then you're told about history of legal systems. Now after so many years we have different legal systems in the world, civil law system, common law system, and then there are different legal systems which have developed for so many years. America had a constitution for 200 years. So there is 200 years of constitutional law in America. A lot to learn from. In fact, we learned a lot from America when we were framing our constitution. So the learnings of the profession starts when you join something or when you join an organization. They have their ethical principles, and they don't teach you like these are the 10 do's and don'ts, yam and niyam. They don't teach you that. You learn. Like you tell your son or daughter, always speak the truth. Will they learn that? They will also tell others, speak the truth. Truth is the correct way to deal with other people. But then they will see, oh, Mama yesterday told somebody something which she did not do. So they will also learn this tact. That all right, we have to preach that we have to speak the truth, but truth is not necessarily required. You have to know when to say what. Right? So you learn. Like you join somebody, their ethical principles, then you adopt. That's why in this profession you have chambers. They said he comes from this chamber. Mr. Nariman came from Kanga chamber. That was a big name. You know, there were traditions and principles. Mr. Nariman is writing forward to a book called Law, My Life, Law and Other Things. Much later, he talks about Mr. Sitalwad, that when he joined the profession in 1950, Mr. Sitalwad had shifted to Delhi as Attorney General for India. So he couldn't really work with him till he came to Delhi in the 70s. And by the time he came, Mr. Sitalwad was old and he would only appear in some matters. And then he describes him as appearing in a matter called St. Xavier's College case. That you're working on a case, you will of course learn the case law and you will learn how to deal with that matter, how a particular case was dealt with by my senior or by my immediate senior. If you join a chamber, now if you join a chamber there is one lawyer or there are some lawyers, but if you join a firm there are many lawyers, but there also you will have mentors, there also you will have hierarchical senior, immediate senior to whom you are reporting and you are working with. And then there are other people in the hierarchy in the institution, so it doesn't really matter. But ultimately, slowly and gradually while working, you learn, and at some point of time, you learn the profession and you go out and practice. Then the third thing is about spirit of public service. Now that spirit of public service is the soul of this profession, I would like to say. It is the soul of the profession. That makes this profession distinct from any other profession. It's like a doctor's profession. You know, when you see a patient die, what will you do? What is your call? You will attend to that patient, no? Whether he is your patient or he is someone else's patient. It is a secondary thing. Whether he has been admitted or your clinic or he is not admitted in your clinic. Whether ultimately he is in a position to pay the expenses that you have made on him by providing the medicine and by providing the services, you don't know. But what will you do? What is the first impression that you get? You will treat that person. Likewise, when somebody comes to you for legal help, do you need a Bar Council of India rules to tell you that you have to provide legal aid? You don't need that. You have the legal equipment and you have to provide that service. And you will provide that service to you. So that is what is required from public spirit. But does that mean that you will not charge anybody? You will go on providing public services? Then how will you survive? You will not survive. So I am only talking about that this is the main thing. But that doesn't mean that people who can pay you for your services, you will say, no, go, I am just doing public service, it doesn't matter. I have given you services, you can go back. In fact, it was like that. We had a small bag behind our gowns where people could pay whatever they like. We don't negotiate with them what is to be paid. You know, so they could give you anything. Like the best movie which I like about law and legal profession is To Kill a Mockingbird, where the protagonist lawyer, he is given some vegetables and food and his daughter asks him that question. So, you know, there's a lot of things that have been said about our profession. It's not that I am telling you for the first time. But we will have to understand what is the public spirit and how do we ascertain that public spirit. Who are we as lawyers? What do we do really? You know, in this profession, what do we do? They say that we are a very important aid or component of public administration of justice. Right? So public administration of justice, you are assisting the judge, you are helping the judge in arriving at a decision. He is discharging a public duty. You are discharging a public duty by assisting, by helping him arrive at a decision. Of course, you are helping your client by providing him with representation. And there we will talk about the duty to the client and duty to the court a little later. But let's first understand the concept of spirit of public service. How far we go in that spirit of public service? Do we go till the stage of extinction? Or do we strike a balance? Not compromising. I am talking about a balance. And that is something for all of us to exercise our discretion and decide in the given circumstances. Not everybody will have the same circumstance. So each one of you will have different circumstances provided to you, and accordingly you will decide what is to be done. What is the line, whether you are crossing the line or not. But let's dwell on this public service element a little. So if I have to understand legally what is the spirit of public service expected of us, like now we've talked about it being component of the public administration of justice. So we look at what is the purpose of administration of justice. The purpose of administration of justice is justice, right? To arrive at justice, to provide justice. So we'll talk about justice. What is justice? What are the theorists say about justice? The learned senior counsel remembers the preamble by heart. I don't. So, and I don't want to make that mistake. So I have to go to the preamble. I'll skip the first line for the time being. Or let's read it. I think every day we should try and read it once. Because this is what tells us who we are. This is what tells us what is required of us, of our society, what we decided to walk towards. And possibly at some point we have stopped and we have now withering away in different directions. We are going haywire, we don't know where we are going. So possibly we'll have to come back. And as you know, in Big Boss they have some kind of anthem that they read in Big Boss. So as lawyers, I would say that you should have these preambles ready every day before you start your court. You should read it, or you don't read it, but keep the principles in mind, if you may. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, these two words were added later, democratic republic, and to secure to all its citizens justice. To secure to all its citizens justice, social, economic and political. We'll talk about that. Liberty of thought, liberty of expression, liberty of faith, liberty of belief and liberty of worship. Then equality of status and of opportunity. And to promote among them all fraternity, assuring the dignity of the individual and unity and integrity of the nation in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves the Constitution. So, we have decided to secure to all citizens justice. In fact, the other day I was looking at the concept of law, trying to understand what is justice. So there is a chapter, it is a book by Professor H.L.A. Hart. So there is a chapter on justice and morality, where they talk about justice. What is justice? So it starts with justice is just, which is not unjust. Justice is what is fair, which is not unfair. Justice is what treats equals equally and unequals unequally. Right? The principle of Article 14 of the Constitution. You know, the equality. So even that concept of equality has actually justice in it. When you are securing liberty, what are you doing? You are securing justice for them. Somebody is professing a particular belief or faith. Like I like Paramhans Ramakrishna, and I want to create his idol. Somebody will say, you can't worship him. He's not God. He's just a saint. You can't have his temple. The Constitution secures to me my belief. This is none of your business. You are nobody to tell me what belief I have to practice, whom I have to worship, what is the faith that I have to profess. That's my faith. And that liberty, and that's why liberty is different. Liberty is secure to an individual or group of individuals. So it becomes very important that I can be only one person worshipping one God, which I think is God. I'll take a stone and I'll say, this is God. Every day I'll do everything. I'll bring a liter of milk and I'll pour it on it. I'll have all kind of my own created mantras and I'll recite before it. Or I'll do whatever I like. I have that faith, and that liberty has been secured to me. Or at least that promise has been extended to me. But who will fulfill that promise? Tell me, which professionals will help me when somebody is stopping and somebody is coming in the way and state is not helping, which is ultimately it is the state who has to come to my help, right? The state doesn't come to my help. Where do I? What do I do? People are cornering me. I'm minority in that area. A lot of people are there of a particular faith or belief. They believe in Khap Panchayat. I don't believe in Khap Panchayat. What do I do? I'm not talking about religion. Belief is not about religion. But worship is about religion. Faith is possibly about religion. And faith can be about other things also. So, who secures that? You go and earn a lot of money. You set up your business premises in Delhi, a big building where a lot of people will come, and you will tell your juniors, how much have you earned this week? How many number of client hours you have? 100, 50? How much money have you earned for the firm? You are not doing well. You are doing this pro bono case for the last 20 days. How will I pay your monthly salary? I am so sorry. You are disappointed. What do you do? Where do you go? So, of course, I will keep reminding you that these are ideals. We will not have to forget our circumstance. I don't know what are your circumstances. I am talking about what is right and what is wrong. We'll talk about circumstances also. I'll talk about my own circumstances. I'll tell you, I started with 3,000 rupees per month. And that was all that I was getting in a month. And it was good enough for me. I must tell you that also. I never felt a need to go to a friend to ask him for a money. And 21 years, God has been very kind. I never felt that. I had good friends who could extend help. So you can make do in whatever has been given to you as resources. If you don't want to do it, you won't do it. But if you want to do it, you can do it. It's your own will that will guide you, nobody else. Otherwise, theories after theories can be created. Right. So, securing justice, social. I'm so sorry. Social economic and political. So somebody secured social justice and you had affirmative action extended to people who were not getting affirmative action. Recently you had Supreme Court upholding that 10% reservation of what? Your seats have also been increased by 10%, no? For that EWS category, economic weaker section, whether they are from that group or not, and that group doesn't have to get that benefit of those 10%. So these 10% are additional, in addition to that. So that is possibly the economic justice which is being provided to people. Constitution framers knew that we are providing a democratic nation, so there would be people who would be of a particular political ideology, who would be voted to power, and there would be other people who would not be voted to power. Possibly they will be persecuted. What do? You provide for justice for them, that if they are persecuted, I am just giving examples, there can be many. So somebody who talks about constitutional law will tell you, I am only trying to make good that point of spirit of public service. So on that point, what did our constitution framers envisage a duty for us? I am only on that for that moment. And I am not telling you not to have practice in commercial law and any other law. But I am just trying to understand what is our profession. And that's possibly the scope of this discussion. And we'll of course talk about that. Likewise, securing liberty, we talked about equality of status and opportunity. Again, those affirmative actions are providing that. What they talked about was a very beautiful thing. Fraternity. That aspect I always liked, but I couldn't get much case law on that, and assuring the dignity of the individual. So, what is a fraternity? When do you break up bread with someone? How do you do that? You break up bread with somebody, you providing that dignity to sit with you and eat, isn't it? So they are saying that is the fraternity that we want in the nation. It's not a fraternity of a particular group of people who have belief in a faith. They are talking about fraternity of the entire nation. Just because they are all Indians, they can sit together and eat together. That is the kind of fraternity. I can give you that dignity that you can sit with me, there is no problem. Whoever you are an Indian, isn't it? Come, sit with me. That is the fraternity that they talked about possibly. That is the fraternity that possibly they talked about. That people will be so friendly with each other because we've achieved this freedom after so much of struggle. So many people have slain their life to get here. So they thought that we are quite sure that we'll get that kind of fraternity. And these ideals, although they were drafted towards the end of the framing of the constitution, but possibly now, after so many years of constitutional law development, we can say that these were the basic ideals that we traded for when we framed this constitution, that at least this much we will have in our society. And this cannot be disturbed. This we have to achieve today. Adding of secular and socialist, it's a debate for another day whether that was required or not, but that is not the scope of our discussion today. So you do it, how do you do it? Now the question is, this is the profession that you do it, how do you do it? How do you do this public service? How do you help people? When they are in need, you provide your services. When you provide that service, when you have a proper understanding of it. When I came out of college, we had a friend, he was expert of everything. So he said that now I have become a constitutional expert, Satyakam, and I am no less than any constitutional expert in the country. Congratulations. So when we came out, possibly I was also of a view that now we have learned everything of law and now we have to go out in the market and practice. And it's only a matter of time that people will know that Satyakam is also a name to reckon, like any other big name in the profession. So when you come and join and see the work which is happening, you are only humbled and you only realize it's a long way to go. I have been walking on this path for 21 years, and the path that I have chosen, I don't mind walking for another 20 years because I am thoroughly enjoying it, and I want to convey what is it that I am enjoying, what is it that I am doing which gives me this kind of enthusiasm to go on and on for another 20 years. 20 years is big time. So what is that provides us with this kind of enthusiasm? So you join the right person, he guides you in the right direction. That is the first and foremost for all of you to decide. How do you decide that? What do you do? What can you do now as law students? You can now read biographies, which we read partly in college, partly after college. And it's very easy to find out what are the biographies to read. You can read biography of the famous first Attorney General for India, M.C. Setalbar. His book is very famous, My Life, Law and Other Things. Justice Chagla, he wrote a biography, Roses in December. You can read that. Justice Hidayatullah wrote a biography called My Own Boswell. You can read that. Two people whose biography I always wanted to read and who never wrote any biography, possibly they didn't have time to write biography. One is Mr. H.M. Sirvai, who wrote that Constitution of India, and all I know is that he could have had a lucrative career, but he was so engrossed in completing his book that at the cost of his professional work, he was offered to become Attorney General for India, but he did not take it. There are collection of some of his correspondences which you can read, like Evoking H.M. Sirvai is a collection that you can read, and there is another Sirvai Legacy. There is another book which has certain collections of his writings. You can read and feel what kind of a lawyer he was, and you can guess. I leave it to your imagination. But it was a very good guess. This book, Constitution of India, starts with another book of his, A Partition of India. So he talks about partition in a very positive, lawyer-like way as to how those transactions took place. Possibly he was not party to it, so he could see as a bystander how things are happening, and without being impassioned about it, he is presenting to you a picture which is different, a picture which you need to know. If you have to read your constitution and understand your constitutional law, you cannot do it unless you understand how this constitution has come about. And unless you know your constitution, you don't know what is required from you. Because what is required from a person who has to help aid administration of justice, which is the basic requirement in the preamble, is the first word which is to be secured to the people. And I told you even the rest is about justice. So everything is about justice. So how do you do it? You do it when you have the correct judgment. And how do you have correct judgment? When you have all the facts. And when do you have all the facts? Then you gather those facts and apprise yourself with those facts. Then only you understand what has actually happened, why these theories have come about. Right? They are one line, that one line of equality of law and equal protection of law. There has been bloodshed in another country. It took 70-75 years for them to secure those lines, that one line which was given to you on a platter. because you were a modern democracy. You had the luxury of various constitutions before you, and you had great lawyers helping frame. Granville Austin has written a wonderful book on Constitution of India. He has written actually 2 books. I am talking about the first book called Cornerstone of the Nation. Towards the end, he is given appendix, and in one of the appendix he gives 21 names of the prominent people who did the main work in the constitution framing. Out of the 21, I find 13 were lawyers. They were eminent lawyers. So, in my humble view, you should spend time as students to read and understand the manner in which we gained independence, and we have to cherish those ideals and look around and see whether they are being followed or not. I don't think that you will take much. In fact, reading every day's newspaper will give you an idea of where we are, where do we stand, right? So biography is one key that I have provided you with. Easy to gain some idea of the traditions and the ideas on which our, those former professionals who have been in this profession and have made their name, how did they do that? When I joined my senior, he was aware of my situation, that I don't have a house in Delhi, I don't have a backup, and how do I survive? But then he only told me that you will survive if you have intention to survive. You don't need anything else. It's the willingness to survive is all that you require. You don't need to ask me how as a junior I will do what, and how will I get my food, and how will I get my lodging. Of course, food and lodging is something that the state should provide to young lawyers. Some financial assistance should also be provided to the young lawyers so that they can be independent. So this word independent we will dwell on. And that's very important. To be in any service, and particularly in this profession, to be independent. Why do I say? They every day talk about independence of judiciary. And we say that judiciary should do this and shouldn't do this. This hobnobbing between the executive and judiciary is not a good thing. It should stop. Why they are saying this, and this judge made this statement supporting this view of the government that is not required from a judge. Right? So, in America at some point of time when they were talking about judiciary, they said what the judiciary can do. At the most they can deliver judgment. That's not harmful. Ultimately it has to be implemented by the executive. So they thought that it is a very innocuous institution. We don't have to worry about it. But they didn't know that lawyers and judges of this country were made of a different metal. And you all know that after the constitution was framed, we had our first election in 1952. So before that, the same Constituent Assembly was continuing, and they had the first amendment, where they added part B and C, 31B and 31C, and Schedule 9, right? And 31A and 31B. C came much later. I am so sorry. 31A was about the agrarian reforms, right? So that was one of the ideals. Lands were held by jamindars in this country. So therefore, we had to dislodge that and distribute that amongst people. So we needed land reforms, and various land reforms acts were enacted all over India. You know, in Bihar also. I am saying Bihar not because I am from Bihar. I am saying Bihar because that was the first act which was added in the Scheduled 9. That was the first entry in Schedule 9. And although A, I think, was not that offending, B was the problem. And at some point of time, it came to be challenged, and the issue was whether amendment to a constitution, whether that is a law or not under Article 13. And that was the issue which was decided. But in Golaknath itself, I am not on this constitutional law aspect, I am on a different aspect. Golaknath itself, this question of power of amendment of the constitution. Why I am coming to that is about the independence of judiciary. So I am looking at this from that angle, not any other angle. So I am talking about executive and legislature and judiciary. And in that view I am talking about, can you change your constitution? That was the issue. And then there was a lecture in Banaras Hindu University by a professor, a German professor called Dieter Konrad. And he talked about implied limitations on amendment. And that implied limit are basic structure of the constitution. And one of your lawyers, Palkiwala, was the one, although it was Mr. Nambiar, who wrote in 1966 to Dieter Konrad to find out whether he can use his article in the court, in the Golaknath case. And he said, all right, you can use it, but you will have to use the entire article, don't use portions of it, use the entire article. But then Golaknath, we know what happened. And finally, in Keswanand Bharti, it took a shape of law, although by a rather thin majority. And you know what happened thereafter. You know, there was the unprecedented taking over of the institution by superseding 3 senior most judges, and number 4 was made the Chief Justice. But the point is about independence of judiciary. That is the point that we are at. We are not at 368 and the amending powers of the Constitution. I am talking about the power of the government and the power of the court. So basic structure gives me a power of the court. The power to do things, to correct things, if it is going off the line, it is offending the constitutional ethos, then I can step in and correct. I will not tell you what are those ethos. I will tell you when it offends. That's also a very good thing, that I will not list out which are the ethos. We will see when it comes, and then at that point of time, we'll deal with it. Right? So, that is one of the very important milestone in our constitutional history. It's a very important milestone that was achieved, the basic structure doctrine. And thereafter, you know, a lot of judgments have come, and that's the law today. But how does it help us in understanding independence? So like I started with profession, I will go to independence. What is independence? Independence from our own miseries is also independence. We think that we are poor. Is a misery. We think that we are not poor. That's in the mind. You think that you are happy. You think that you are not happy. You're sad. Sometimes you deliberately try to create a sad mood. No, I'm sad. No, I'm actually sad. No, that's actually in the mind. Right? So somewhere in the mind, that exercise of independence starts. It's mainly a matter of a very soft tissues in the brain which decides what is to be done and what is not to be done. And that fraction of second you take a decision. Should I do it? Are you coming for coffee? Who's calling you for coffee? Who's paying for the coffee? Will you go for a coffee? Will you compromise your independence? In Before Memory Fades, there is a story about somebody bringing a sack of potatoes, and one judge refused it, the other judge accepted it, So, when the matter was being heard, the one judge who had refused, he tells the other judge, you know this guy, he has audacity to send me the sack of potatoes. So the other judge says, you didn't try them, they were very tasty. So the point is, so long as it doesn't affect your independence, I don't mind going for a coffee with somebody. You know, if it is only a matter of coffee, I would of course like to make friends with people, because that's one of the most important aspect of advocacy, that you have to have fellowship. Like Abbot Perry's those 7 lamps you would have read of advocacy, this is one of the lamps, lamp of fellowship. So you have to have that kind of an understanding. You have to have only friends and not enemies as an advocate. That's something that you should always keep in mind. Make more friends. You will learn from others. They all are having experiences. Every day they go to court, they have their own experiences. You are having your own experiences. If you collect all the experiences together, think of it, how prudent and how better and how developed you would feel if you have that kind of an experience sharing amongst you as friends, as fellows who are practicing in the same court. So that is a very important aspect. We were on independence. So let's now dwell on independence. What is independence? So when you join a chamber, actually the independence test starts from there. How does it start? You are taking a favor from your senior when you are accepting a salary. So you are compromising your independence at that very moment. It's okay if a senior is giving you money as a stipend. That's all right. You will also give it to your juniors at some point of time. You will grow. And this is how system works in the society. You know, we learn and we teach. I don't know whether you've heard of Matre Ran, Pitre Rin, Guru, Acharya Rin. So how do you pay them back? Can you give back to your teachers the learnings that he's given you? Never. They say you cannot return it. So how will you return it? By passing it on, isn't it? So that's understandable. I am on the question of independence. I am not on the question of whether you should accept what is being offered to you. By all means, you should accept it. Not because you are in need, because it is being given to you. You should always accept it. You should accept his teachings. That's more important. You are not going out and becoming a full-fledged lawyer. If you have that notion, give them up at this moment. But don't feel any less. I must add this word of caution. Don't feel any less. You can be a lawyer the next day, possibly. You should be ready to be a lawyer the next day. That's a different aspect. But that learning, when you are going to learn from somebody, there are basic principles of learning, of a discipline. Those discipline principles will have to be followed. So what are the principles that we have to follow? So we will take from some other profession those principles. So there is a traditional profession, a soul-stirring profession, if I may call it, a profession of classical music in India. It's been a very old profession and practiced for many years, and people would learn for years and years together under a master, and at some point of time when they are almost old, they are getting a chance to perform on their own. Otherwise they sit behind their senior. I'm just opposing the senior concept here, and they hear the senior argue, or they hear the senior make the recital, and they fill in between. Like a singer is catching his breath, then the junior then fills in, and then the senior again comes back with his stance, and then he makes his performance. But the point is not how it is being performed. The point is how it is learned. So there is a very famous musician in India who produced almost all the great musicians of the present or yesteryears. You've heard of Pandit Hariprasad Chaurasia, you've heard of Panna Lal Ghosh, you've heard of Pandit Nikhil Banerjee, you've heard of Ustad Allah Rakha Khan, you've heard of Pandit Ravi Shankar, you've heard of Annapurna Devi. If you have, they all come from the same family of musicians. His name was Allah Diya Khan and his daughter was Annapurna Devi and his son was Ali Akbar Khan, who was a sarod player, and he was himself a sarod player. So he had to learn from a particular master, and he was a big master, he was confused. So every year that master will come and perform in his locality. So he'll go stand and do salam and then come back, and then they say that he lied down in front of his this thing. And so he said, "What do you want?" He said, "I want to learn under you." "But what will you do? You're so poor and you can't." Music is a tradition. People who are rich and who can, they withstand the basic needs, etc., etc. So how will you do it? You can't do it. So he said, "All right, you don't teach me anything. Just allow me to serve you as a servant, and I'll stay with you. And you don't have to teach me, but keep me with you. And I'll learn at your feet without disturbing you, and you don't have to do anything." And he became a great musician, and I'm told many instruments he just take and play. And he was a master of music, and as you see these names, possibly you would have heard. Some of them are still in the world, some of them have just passed away, and their music is still, echoing. So you can be familiar with these names. So our profession is also like that. You go to court, like I go to court even today, and I prepare myself, go and appear, and every day when I come back, I have some learnings which I bring back. I should not have been that. I should have controlled my temperament, or I missed that point. Possibly I could have also made that point. I forgot about it. So there is a kind of passion at play when you are appearing in court, and a lot of other things are happening. So keeping your cool, sometimes it's not possible. Sometimes you miss out certain points. So we are learning even today. But I am talking about starting your learning. So you have to learn with somebody who's practicing, who is learned himself. You can't just join somebody who's himself not learned the basics. So you have to have somebody who's carrying those basic values and principles, and he can give it to you. So you go there and you learn with that person if you want to come to litigation. I think learning as a part of training is required. I just wonder why, like the medical profession, they don't teach law in this country. Possibly then your task will be much easier, and you can be declared like the doctors are declared as doctors, and you can still train. Of course, we continue to train even today. Even today when we see good lawyers arguing and making their point, we still learn both the substantive law as well as the advocacy. So that exercise will not stop. But to have a good deal of understanding to start with as lawyers, you need to understand this under somebody who could teach you, who himself had that tradition. Or if you don't get somebody, you have a lot of material today available in the market from where you can learn. People are making podcasts, there are people who've written books. So a lot of books, I have just named a few, but there are many books. In fact, there is no dearth of material which is today available which was not available when we started. There were only few books which were available at that point of time. Possibly they were out of print. Like for Roses in December, I had to wait for some time to find a book. I made several visits to Bharatiya Vidya Bhavan because it was Bharatiya Vidya Bhavan publication. And on Kasturba Gandhi Marg, they had a small office there where they were selling books. So, and then finally I got that book. So today I don't think that this kind of a problem exists. So you can easily go and read these books and think about the personality, because book is a second or third hand information. I don't want to get into it that whether autobiographies are truths or not, but that's not our scope of discussion today. Our scope of discussion is to understand, to have a feel, like you said, that it is like a trade and business. I'm feeling it has become like a trade and business today. People are actually running it like business, which possibly was not, and there is a good reason why it was not, and it should not be. Right? You should not become a business machines. You should become good lawyers. You will help people, they will give you money. Now about reward, money reward. Tell me, you are on deathbed. Some doctor saves you and gives you life. Can you pay him? Can ever you can recompense him for what he has given you? You cannot. And he should not also expect from you, because he did what was expected from him. But what he did is something which cannot be compared or with in terms of the material aspect. So therefore all that you say thank you, and you remember him, that he gave you your second life. Likewise you are on your course to the gallows, and somebody saves you from the gallows. What can you give him? Can there be any recompense for him? I am not sure that we can recompense them for the kind of services that has been rendered. So when we are doing a matter, it has nothing to do with what is paid. It is the matter which is important for us. What is the legal issue involved? How will it help my client, and it will help others also? If we achieve this, if we win this case, it will help hundreds of people who are like my client. He is suffering, others will also not suffer if it is the judgment of the High Court and it is the judgment of the Supreme Court. Why others will not suffer? Can you tell me? Yes, it will become precedent because Article 141, and also because both these courts are courts of record. Yes, you are right. Article 141 in a way has that doctrine of precedent. Thank you, ma'am. But yes, also because they are courts of record and their orders and judgments have to be followed. Right? So that's the point. But so therefore, we have now understood that livelihood, a means of livelihood, is not the ultimate goal of the professionals who follow this profession. It is a byproduct, if I may use that expression. Livelihood is a byproduct. It is a profession of service to the people. You are serving the administration of justice by helping the judge. And I mean it. Judges may or may not agree. Why not? Why will they not agree? In fact, they look for good assistance. Today the pendency is not because of the judges alone. It is because of the mediocrity in our profession. We are not able to help them decide the cases. We are not ready with the matter in the true sense. Right? We don't have all the cases available with us, and what is held here, what is held there, what is my case. What is a case? You have to master your facts, and you have to know what is the applicable law and what is the latest law. That's all, isn't it? The other side has to come with that. and you have to help the judge understand. Judge may have his own ideology, but that's all right. That is his decision-making power that he has. He will make that decision, and that is why possibly there are appellate remedies available. So if a judge decides wrongly or he decides against you and you are aggrieved, rightly or wrongly, you have remedies available. If you have no remedy available, you have a remedy in writ jurisdiction. That is also very clear. So you go there. But non-decision, it's better to have a bad decision than no decision. At least the case moves on and goes to another court and we try our luck there. So the delay is not primarily because the judges are not deciding the cases. That can be one of the reasons that we don't have enough number of judges. But it is also because possibly the lawyers are not doing enough to get those matters decided. Possibly we are not ready, or I don't want to make any value judgment on that. So I would like to say this, that if you are prepared fully, it will help secure speedy justice also for the people. Now, securing speedy justice, you are again doing service not only to your client, but to the society at large by providing a speedy justice to them, isn't it? So, that's another very important aspect. Now, the speedy justice, right? So, we've then possibly understood what is our profession and what we are going to profess and what is the nature of this profession. Now let's talk about ethics. So we started with that. That's the topic, advocacy and professional ethics. So let's talk about ethics. So I'll go back to the very beginning. Satyam vad dharmam cha. Follow the basic principles of honesty. That's all is required. In so many words, that's all that is written in the Bar Council of India rules. What is written? Be honest. Be honest to the court. Be honest to your client. Be honest to your opponent. Now, possibly I am stretching the word honest a little too far. So, or I am including being honest, being fair. So I am adding all those things here itself. So your opponent, what you don't do, you don't call his clients and directly deal with his clients. You possibly share with him all the relevant material which you are going to share with the court. That is the basic practice that we have. Your client, you have a lot of duty, and there we talked about the duty to the court and duty to your client. It appears that there is some contradiction, there is none. So I was hearing some speech recently, and a very senior judge, he was talking about another former Chief Justice who was sitting as a single judge, and he was appearing before him. So his client said something and he's blurted it out. So the judge said, don't be his master's voice. So you are not a mouthpiece of your client. You are a professional. He's coming to you with a cause. He has a problem. It has to be secured. Now everything that he says, every scandalous thing that he's telling you, you don't have to reproduce it. That's why you are there. Otherwise he would have faced the court. You are there because you have to see and see all those material to the material which can be presentable before the court. Always keeping in mind your client's ultimate goal. It's a different matter altogether, but you will not be his mouthpiece. You have a duty towards the court. You are an officer of justice and a friend of a court. So you will be friendly with the court, isn't it? You will be respectful to the court, and you will try to be honest and fair with the court. And You will be ready with your case, which is a very important aspect that we talked about with your case. That is also an important duty to your client as well as to the court, that you are ready with your matter. You've researched properly, you've read the law, and you are presenting the law. What is important, that you also are ready with the law which is against you. So at times you will find that there are judgments against you. So there are tools in common law to distinguish those judgments. They may not apply on the facts of your case. And if they fully cover on all fours, what do you do? If I am in your case, I'll go and say, my matter is covered against me. And I do it on a regular basis. Because that is to be done. That's your duty to the court. If there is law which covers your case directly and fully, entirely, even the other side doesn't know, you have a duty to point out to the court that I am sorry, my lord, I am covered. So this is the case, this covers fully. And judges are also very good. Sometimes it doesn't cover you and you've read certain aspects. They'll say, but Mr. So-and-so, kindly read this. Possibly it may not cover your case. Go back and prepare and come back again. They give you an idea. It can happen. We are all human beings. It can happen. Sometimes we feel that it is covered. But you've done your duty. We are today talking about your duty, not right and wrong. We are talking about a duty. Duty to the court. To be fair and honest with the court. Duty to the client. To declare clearly. If you have some conflict of interest, have you dealt with some cases which of his opponent? Maybe it's not the direct case, but possibly it is your duty to your client to declare that although that gentleman is not come to me for this particular transaction, but I must tell you that I have appeared for him in so and so manner. If you still want me to proceed with the matter, I am ready to take up the matter. But I have a duty to tell you. These are the things. What are they? They are honesty. You have to be honest to the system. You have to be honest to yourself. Are you doing enough for your client? Are you reading your brief properly? Have you done the research? Another thing about the client is very important. That Krishna Swami Iyer's this book called Professional Conduct and Advocacy. It's a very good book. We were all recommended that if you want to read something, read this. And you read it. It's been written in a very simple language. And it's available on archive.org. So you don't have to buy it if you want. You can simply download it and read it, because it's also not available in the market. So possibly you might not get it, but you will get it in your libraries. If you have a good library, you will get it here. And but read it. It's a very simple book. It will give you an idea about what is to be done beyond the Bar Council rules on professional ethics. It was written in 1940, much before, and he was a visionary. And he's such a simple person. He's telling you things. Don't be angry in court. Don't lose your temper in court. You know, those basic things, they are very important. You should never lose temper in court. You should never get angry in court, even on the opponent or on the judge. Of course not on the judge, but even at the opponent. Keeping the cool is the best judgment that you exercise on yourself. Exercise that judgment. See, most of the time we have to fight with ourselves. The exercise is so immense. Reading the case, finding out the case law. Where is the time to fight with anybody else? There is no time. If you have been given a matter and you have been given 7 days to prepare, it is much less. You will have to read hundreds of judgments as a young person to understand every aspect of it. It is easier for us, possibly most of those judgments we have read 10, 20 times, so we know exactly what was said, what was the fact. So we refresh our memories by looking at those judgments, and then possibly we come to the point. And if we are cross-questioned, possibly we can go back and tell the judge what was the facts. It remains in your system. You have to remind yourself. But as a young lawyer, every time there is a reference, go to that reference. a section has been provided, read that section. As part of your advocacy training, you go to the section, try to read it. In this Before Memory Fades, Mr. Nariman talks about advice which was given to him by Mr. C.K. Daftari. So he says that he told him that instead of getting into the files, sometimes it is better to think about the case. I went to hear advocacy lecture by Mr. Nariman in Library 2 in the Supreme Court when I was first year or possibly first year of my practice. So he emphasized on that. After many years of his meeting with Daftari in Bombay, and his entire theme was thinking. Thinking makes you a better lawyer. But how will you think? You will think only when you have read your files fully. You read all the judgments fully. And then try to connect the dots. I'm so sorry. I'm exceeding my time. Thank you. So I'm so sorry. I can talk all night like this. But we have to put a full stop at some point. So there's a lot that I can talk about. Call me next time and we'll continue this lecture further. Right?
Please put a conclusion and...
Yes, conclusion and doubts. तुमने तो कमांड कर दिया यार, कमांड के बाद तो कुछ बचती नहीं है.
नहीं सर, मतलब मैं तो सिर्फ...
Okay, no, I'm not abruptly closing. So we were talking about advocacy, right? A little bit. You can read. There is a lot of material which is available. Sit down. I'll take another 5 minutes. So there's a lot of material available. If you want to read, you just have to find out, and you read about it. But advocacy is not something that can be taught. Eloquence is something that can't be taught. Wit is something that can't be taught. You gain it through your experience, because the wit of a lawyer is not something that can be taught. It's something that you gain through your years of experience. So you will have to gain experience. You will have to go and sit in the chamber and see how they conduct themselves. You will have to learn. From smaller things that they do, you will have to learn. As far as the client and advocate is concerned, there is one thing that I wanted to tell you about, which is very important and which I always come across because I have a government client. They come to you, they are themselves very smart. They know that lawyer has to be told on need-to-know basis. So they will tell you that this is what has happened and this is what you have to do and you get me this. Now it is your duty to the client as well as to the court to get to the bottom of this. So the first fight that begins is not with the opponent. The first fight that begins is with your client. You have to thoroughly cross-examine him. By not antagonizing him. You can't cross-examine him. Then he will run away and say, no, this is not the right lawyer for me. We'll go to another lawyer. There is no dearth of lawyers in the town. So I'll go to someone else who's more pleasant. This guy is not pleasant. And he's already made up his mind against me. No, not like that. But you have to gather the facts, the true and correct facts, so that tomorrow you don't face an embarrassment in court when certain facts are put to you and which are fatal to your client's case. If you know them beforehand, you will know how to handle those facts. And lastly, this is a very big topic and it's not possible in one day to tell you everything. 1962, Mr. A advocate, there is a constitution bench judgment. It's a very unique case where a lawyer was writing postcards to everybody, soliciting case, you know. So soliciting brief is prohibited. It's a prohibited conduct. You will still find, I find every day some pamphlet is circulated that for drafting, for this, that, you contact so and so phone number. This you can't stop. Ultimately, lawyers also come from the society below, and in society you have all kind of characters. When we are talking about the right things, we are only talking about the right things, right? And it will be always left to you to decide, and you can create your own benchmark that you want to follow, your own moral standards that you want to follow. I have already said that what is provided is basic, right? So he was punished with 5 years suspension, and Supreme Court said this kind of weak moral fiber is not required for this legal profession. You know, you have to have a very high, strong moral fiber for this profession. So that is from where this moral and ethics become very important. And the last judgment that I will talk about is providing representation to the people. That's also a duty that we have. It's a very important duty, and there is a very good judgment of Justice Karju on that point, that Bar Association decided that the police officers will not be defended and no lawyer will appear, and that resolution was challenged, and the Supreme Court frowned upon that resolution. It was struck down, saying that it has been the tradition of the bar to provide representation to people. You are not the judge to decide their guilt. It is the court that decides the guilt. So even if you feel that your client has done something which in your moral standards are wrong, you are not the judge. You have to give him the representation, and the best representation that you can give him. You have to be faithful to him, and you have to provide. That is the duty. Although it is a conundrum, you know, you will fight with yourself what I am doing, but you have to do it. That's part of your duty. It's a very important duty to provide to the society the legal representation when they need you, right? So we can close. At least I can stop talking so that you start talking, and we can have that exercise for 5 minutes. 5 minutes. So please, if any one of you, I am quite sure a lot of doubts would be there. So I don't doubt that you don't have doubts. But let's take 3 questions. So 1.
Sir,
Yes.
3 questions from the same person, 3 different.
That we will decide.
That is one question.
That is
No, that's as you talked about the transformative nature of the constitution, as well as the ethics, what to do and what not to do. So as we can see, the society has evolved, and nowadays we totally accept doing wrong is acceptable as well as commendable, but doing too wrong is what we frown upon. So how do you decide, how do you draw the line between the wrong and too wrong? Because at some point of the time, each and every lawyer, each and every person of the society has done something wrong in his life, something bad to someone else. So where do you decide the line? That is wrong and that is too wrong, but that is totally acceptable, but that is not what I should not be, should have not be something like that.
okay. So you are saying right, wrong and too wrong.
Yeah.
Right, so there is a scale of right, wrong and too wrong. So I would advise that if everybody is doing it, that doesn't make it right. Right? That's the answer to your question. It's a very simple answer. But I understand what you are saying. That moral standards are changing. That was my first motto in law college. It was Ranjit D. Udesi's case on Lady Chatterjee's lover. And it's a 1960s decision, possibly 1968. 58 or 58 or so. And the same topic was given. And I only collected books of present day and told them that look at these books and now judge with the scale of today's morality. So you have to have that scale changing, no doubt. The scale is not constant of wrong and right. That's what I said, that there are basics, and whatever higher you can go to. If you can't go higher, then don't go below. right? That's the basic. So today, when you have been provided a list of professional ethics, the moral standards which has to be maintained at a bare minimum, that has to be maintained. Now I'll answer your question with an example. So one of the rules says that you cannot appear as a lawyer before your wife as a judge, the spouse, your brother, your sister, your grandfather, your father, your cousin word is also there, and brother-in-law, sister-in-law, etc. But if you have somebody who is not falling in that category and related to you, and you've been as close as your brother and sister, people are appearing. That's one. The other standard was a standard of my senior. He had a friend, had no even distant relation with that person, who was a judge of a high court. In fact, I heard him telling him that, why don't you appear before me? He said, no, I can't appear before you. That's all. It's for us to decide. Who will decide about our morals? Morals is a fight within. When it comes out, it's already beyond that line. Then it is coming out. Then it's a matter of something else. Otherwise, the fight is only in fight of morals. Always the fight of morals happens within us. And we have a standard to maintain for ourselves. We decide what we want to do. Nobody is holding your hand and telling you to do it. Circumstances don't hold your hand to do the wrong thing. Mahatma Gandhi, in that very fine book for all of you to read, Law and Lawyers, it's extracts from Mahatma Gandhi's autobiography, you will find. He says most of his cases, which Anuj will talk about when he talks about, he started mediation. Almost all his cases he would mediate and finish. Parties are riven asunder, that's the expression used. That's all that we have to solve, that dispute between two parties. Get into their heart and soul and see what is the problem that is coming in the way. That's what you do. So as a lawyer, money. Why should I bother to get the matter settled? Why should I bother to tell my client, sitting somewhere the other day, somebody called me to tell me to file a transfer petition. And I told him, why are you filing a transfer petition? It's a simple case, why don't you sit together? He's ready to sit with you, sit and finish. So mangni mein nahi chhodenge. So I said, if mangni mein nahi chhodenge, then you ask for whatever you want. At least put it to him and then find out. Rather than coming all the way to the Supreme Court to get the matter transferred, and what will happen? You will ultimately have to fight, and it's your own daughter. What are you doing? You are a lawyer yourself. And I have done that in many matters. The question that you put to Mr. Ghosh towards the end, and he said that I'll deal with it. That's the final question that I'll deal with. So as a junior, at least I know 3 of the people who wanted to join me. They came from different states. I sent them back. For a young lawyer who wants to learn, it's always better to start with the trial court. It's always better. And each of you come from somewhere or the other. The nearest court would be a trial court. Go and work there. Cheaper to stay in those areas, easier to learn. Reading will have to be done by you. No senior will read for you. If you think that your senior will read the judgments and tell you what the judgment says, that you can do there. So try and practice at least for a year or 2 in the trial court. And everywhere there are good lawyers. It's not that only Delhi has the best lawyers of the country. They all have come and they have come to Delhi, and there is no other place. Every place has good lawyers. Go to any district court, traditional courts. And most of these courts in MP and in UP and Bihar and Bengal, you will find that their courts running from ages. And their families after families have been practicing in those courts. So no dearth of lawyers. So in Mahabharata, one question that Yaksh asked Yudhishthira, that who is the most happy man? So the answer was that one who doesn't have to go to a foreign land to earn his wages, and he can have his 2 meals at home, is the happiest man. So the point is, if you can be close to your home and study for some time after studying from this college, because this college can't be here in every small district. You are a national law university, right? But every district has a district court. Go and see cases happening in the revenue court. It's even older than the district courts. Those revenue courts are much older. They have their language which even I find it difficult sometimes to find the meaning of those words which they use in those courts. Are you getting my point? So go there. Your dream of practicing in the Supreme Court will still come true. A year or 2, please spend in your own district. That's a duty towards the people from where you belong. So that duty you discharge by going to your own hometown and practicing in that court for a year or 2, and then go wherever you want. You will at least find the basic understanding, and it will be easier to start your learning as professional. You know, you don't have to always go to big cities and go through all that. Half the time you are spending your energy in making ends meet by organizing the lodging and food, etc., etc., etc. All that is not required. So you can easily go to a district court and practice. Those who are not from Jabalpur, it doesn't matter. They don't have to go to the High Court. In fact, what is the point in going to the High Court at this stage? You have to understand the basic learnings of the court and the lawyer, which is easily available in the district court. So I would request you all to try and think about practicing for some time in district court if you want to take up litigation as your profession. Thank you so much. Thanks.
So actually I also have a question, but due to paucity of time, I may not ask you that question.
Okay. So you want to ask or you don't want to ask?
No, sir. So if you permit me.
Yes, please, go ahead.
So sometimes we see that, as Sanjay sir also told us, that law have to work according to client. But so sometimes you see, you face those clients which force you to do odd work, like against your ethics. So how do you deal with that, sir?
Don't do it.
So you cannot say no, sir.
Why not?
Since you are junior lawyer, sir.
The first thing is that you have to learn to say no. I am sorry. I will not do it. That's all that you have to say. Say that. I'm sorry. I will not do this. Say that.
I'm sorry, I cannot do this.
Yes, that's all that you have to do. Nothing else. It's so simple. It's so important. Yes.
All you have to say is no, but there is a chance. Like in the practical scenario, I have to pay rent, I have to pay my food bills, I have to pay for my lecture fee, and all these things I have to do, and it's the end of the month. Now the client is coming to me with the money, like, okay, I'm giving it to you.
Don't hire a house which you can't pay for. Have a humble accommodation which can be easily accounted for. Are you getting my point? Don't go to a locality which you can't afford. You will go to that locality. I am giving you that word. Just wait, have patience. You will have everything which you want. This profession will give you so much that you will not even think of today. Just have some patience. When you go to that Sai Baba temple, there are 2 things written on right and left. Tell me what are the 2 words?
Shraddha.
So you know everything, I don't have to tell you. Just follow that. Have Shraddha in yourself. and support. Perseverance. Have that. That's required. Nothing else. You will get it. Right? Don't say yes to something which you don't want to. In fact, you should be emphatic in saying it. Because you have to say no to yourself also. Because there is somebody sitting inside you who is telling you, why not say yes this time at least? I'll have something. So you have to be so emphatic that बाहर वाला और अंदर वाला दोनों सुन ले कि भैया ये नो मैंने नहीं करना. ठीक है जी? Thank you.
I wish to express my sincere gratitude to Satyakam sir for your wise words and eye-opening session. Sir, you gave us food for thought on how our profession is not just about money and material, but it is about the duty we have to serve for the just and fair, keeping in mind the very great learning of our very own preamble of Indian Constitution. And since Ashit sir is not here, because he would be very happy, as sir has told us about Servai sir. So he would be very happy with the quoting of Justice Servai and the book about the Constitution. So with this, I'm thankful for your insightful thought and experience you shared with us. Thank you. So we will have a half an hour high tea break, and after that we will have
Can we lessen the break if everyone's okay?
Sure.
Is a 10-minute break okay?
Actually, the session
It has
it's
been arranged
4:45.
for you, and then half an hour later the students are already here. So after the high tea,
So do we need high tea?
as per your wishes.
Yes, ma'am.